Hey everybody, welcome to the conversation. How you guys doing? How you guys doing? It's been a very long time. It's of course the usual time, but the week feels a bit longer. I don't know, maybe because of the rains and the weather this week. But yes, most welcome to the conversation, ladies and gentlemen. Doreen, how you doing? How you doing? Nice to see you tonight. Kindly. Hey, Eli Olua. How are you doing, Eli Olua? How are you doing? So, guys, tonight we're going to be talking about ownership of property by minors in Uganda. And of course, for this case, we are giving it context in Uganda, but definitely we're going to talk about ownership of property by minors, the youngsters. Yes, Council Philip, nice to see you. Now, I have a very important announcement to make, of course, at the beginning of this conversation. First and foremost, tonight we're going to have Council Philip Munabi taking us through this conversation. He will be stepping in for Council Alan. Council Alan is engaged somewhere. So, as I welcome you all to this conversation, we're going to be having an engagement with Council Philip Munabi for the first time. He's going to be our mainstream speaker tonight. And I'm very excited because we've already engaged with him. But tonight we have him fully on this conversation. So, Council Philip, allow me to send you a request. Or you can actually send me a request here for the mic so that I can extend it to you. Hi, Diva. How are you doing? Hello, Herbert. Nice to see you tonight. Kampala has been very cold, guys, for some days now. The weather feels like, ever since Edie, we've been in a cold zone. Yeah. So that's why I was saying the week feels like longer than usual. But yes, we are finally here. We are back to have another conversation. And I hope you will always enjoy this conversation. So just do me a favor. If you have something that you want to ask about tonight's topic, ownership of property by minors in Uganda, or there is anything you feel you want to contribute, kindly go ahead and inform me. There is a comment section down on the right-hand side of your screen. Just click on that and then you will be able to join in with your question or your comment, and that is very important to me as the host, but also very important to the audience to listen in from you. Council Philip, I have sent you an invite. Kindly accept it and join me as a speaker tonight. Diva, how you doing? Diva is a Lance banker. And of course, we're very excited to have you tonight as well. Okay, I hope you guys can be able to hear me. And I hope that the network is quite clear. Because sometimes we have an issue of the network. So last week we had a very successful conversation, guys. I had the highest number of questions that came through during a conversation like none like any other topic we've ever had. So it was very exciting. It was very interesting. Council Philip, I don't know if you're able to see my request. All kindly go ahead and request for the mic so I can drop it to you. I will just check through here just a little bit. Okay, I can be certain that Council Philip is on, and oh, fantastic! Thank you, Council. I was just checking on our WhatsApp conversation to make sure that I'm updated with the communication because I thought maybe there is something you had. So, Council Philip, how are you doing? Can you hear me?
Yes, I can hear you.
Oh,
I hope
fantastic.
you
How are you doing? And where are we listening in from? Like, where are you going to talk to us from? Are you within Kampala or you are out of Kampala?
Yes, I'm in Kampala, but I just bought myself a new gadget. That's why I was getting hard time to tune in. But then I think I'll use my phone.
Ah, oh,
Thank
fantastic.
thank you
Fantastic.
for the opportunity to talk to the masses out there. I hope we are ready
You,
to go.
Yes, you're very welcome. I just made an announcement to our audience tonight that, guys, and this is what it means actually to be a very, very strong team player. Council Allen is a bit, he has a schedule that is quite busy. So he has asked Council Philip to step in for him. But like I have said before, we've always been listening in from Council Philip, and we are very excited to have him actually on this wonderful conversation. So, Council, as we get started, I'll ask, ladies and gentlemen, please go ahead and share this conversation. The hashtag is Amity Realtors Chats. Guys, there is a lot of people that need these conversations that we share here. So if you have a WhatsApp group, if you have a Twitter group, if you have a Telegram group where you think people could actually be interested in some of these conversations, please go ahead, do share these conversations with them. You never know. You never know who you're going to help out there. You never know who is going to get something from this conversation. So cancel straight away, starting this conversation, and cancel feel free to also take us deeper, because we want to understand this conversation deeply as much as possible. We want to pick out every single detail that you want us to have from this conversation. So cancel, first things first. Before you even define for us who a miner is in Uganda, are miners allowed to own property in this country? Let's start from there.
I think let's start with the first things first. Who is a miner
Okay.
in Uganda?
Okay. Fantastic.
Uh,
Fantastic.
who you might end up saying you're also a minor because you live with your parents or because your parents still pay fees for you, you might end up claiming you're a minor. But
I
who is a
definitely
minor?
wanted to know, because when it comes to owning property, there is always, people have used so many complicated words. You see, now you're there. So, but anyway, let's start from where you want us to start from so we can pick everything.
Let's start with who is a minor. A minor under Article 257C of the Constitution of the Republic of Uganda as amended, Section 2 of the Children's Act, Cap 59 as amended still. A minor is defined as defined as a child under the age of 18 years. That is the settled position of law for purposes of making legal, contractual, or having legal contractual obligations. Any person below the age of 18 years. So you can be 17 years and 11 months, you're a minor. Now, in regard to our question, does a minor have a right to own property? Yes, a minor has a right to own property. Maybe we shall ask ourselves, how does a minor get into ownership of a property? A minor can get ownership of a property by bequeathing the same to them. It's a gift. You give a gift inter vivos. Say you're about to die, you're making a will, you're trying to give out your property or plan your estate. You can give out property to a minor as a gift inter vivos. You bequeath, you give it as a gift. I have given you my land, situated in so and so or such block and plot. A minor can also obtain property through purchase of the same, but we shall see the parameters under which a minor can obtain such property through purchase. But when a minor is to get property, there is what we call a deed of donation, because many times if you're talking of children who cannot write, the age which cannot read or write or understand properly the transaction, there's what they call a gift, a deed of donation. You, as a person willing to grant land to a minor, you'll do a deed of donation to that child, which deed of donation is registered as an instrument onto the title. But Section 59 of the Registration of Titles Act and Article 26 actually, in line with the articles above stated, 257C and Section 2 of the Children's Act, they impute that a minor has a right to own property and can thus own land. That's the implication of it, that the right to own property also goes to a minor. But how does a minor transact? Now, that's the tricky part. Many times people will buy land and say, I'm buying this land, but I'll register it in the names of my child or our children in order to protect it from our relatives or my other women out there. You might choose to grant land to a minor. Under the law, Section 1K of the Children's Act, which is Cap 59, allows an adult person to transact for a minor in land. You can transact in the names of a minor. Say you register property for a minor in the names of a minor, but you have to get an order for guardianship. Section 1K defines a guardian as a person having parental responsibility for a child. It is also a duty of that guardian or any person having custody of that child to maintain that child. Under the same section, parental responsibility means all rights, duties, powers, responsibility, and authority which by law a parent of a child has in relation to the child. Now, here is a question. Is it that only biological parents can get guardianship, or non-biological parents can also get guardianship? Now, the answer is the law and courts have granted guardianship to biological parents of children. The parameters are set for how you apply and what qualities you must have in order to be granted guardianship. But parents of the children, biological mother, have also applied for guardianship. There's a common case of Ayla Mayanja. Ayla Mayanja, it's High Court Miscellaneous Cause number 20 of 2003, I think. Two parents, common by face and common to all, required to have guardianship over a child. One parent wanted to travel with the child outside, the other parent wanted the child to stay. Then they had to apply. The mother actually had to apply so that she can take over full parental responsibility from the father over the child. I have also recently had the similar application where a father had to apply, though in this case the father is living with another woman abroad, so they wanted to travel with the biological children of the husband. They had to apply to court. But when you get this order, it grants you legal authority to transact in the names of that child. You can make decisions for them. You can apply for passports for them. You can register land for them, among other responsibilities. How do you get guardianship? Maybe that would be another question. When you get guardianship, how you get guardianship under Article 139(1) of the Constitution, Section 14 of the Judicature Act, Section 98 of the Civil Procedure Act. The High Court is empowered with the right to grant guardianship. But what qualifies you to be a legal guardian? A legal guardian can be applied for by a person who is above the age of 18. That application is made by way of petition to the High Court. The petition is set out in the law, in the Children's Act, in the third schedule, and it's accompanied by a report of a probation and social welfare officer. These social welfare officers are mostly at the districts. This report indicates that you are ready and in full knowledge of the responsibilities of a parent to the child that you want to take legal guardianship of. Now, when you get an order of legal guardianship, for instance, Philip Munavi is granted an order as the legal guardian of Fred Yugaman. You might want to buy land. Now, I will buy land in the names of Fred Yugaman as a legal guardian. Even when I want to sell that land, I transact for and on behalf of Yugaman. That is the implication of legal guardianship. The law presupposes that in matters that concern children or minors, first, under Section 3 and 4, their welfare is paramount. For instance, you have bought land, you have put it in the names of your child. You have an order of legal guardianship. It's registered under the RTA. You have a title per se, and you want to sell that land. Let me give a scenario of you have taken a loan, a money lender is on your neck. You have property somewhere, but you also have property in the names of the child. Now you're saying, let me dispose of the property in the name of the child, and then I'll maybe retain that property which is in my name. You might be surprised when the courts say, no, let the other property stay for the child, and then you can dispose of any other property. Why? Because the welfare of the children is paramount. I had a scenario in court where, like I've given that description, someone a money lender was on his neck. He wanted to sell off land which was registered in his children's name. The children were 13 and another one was 13, 14, and 9. So court directed that, you know what, we need to see these children. They came to court. When they come to court, the judge asks the children, do you know that you have land in your names? Children were like, okay, no, we don't know. But so court informed them that, okay, there is land which is in your names. It was purchased by your father, and your father wants to sell it. And these children were like, no, he can't sell it if it is in our names. You get it? Because that property is for the child. That is the implication. Much as he does not have the right to do a legal transaction, you find that he has an interest that he can protect. So it was until court had to engage the children more, and court found that indeed the father was responsible for payment of their fees. He was catering for them. The children themselves attested to this. He pays our fees. He gives us food. Like, he takes care. He has full responsibility over us. That is when court granted him the authority to now sell the land to come out of a situation that he has been in. There has been legal scenarios. More to that, there's a case of Ajidiru Luluwa Jennifer versus Ndera Justin, and another is a case of around 2016, where Justice Mobiru says that in matters of this nature, where legal property rights of children are involved, Yet by virtue of their status as legal incompetents, the children do not have capacity to safeguard those rights on their own. Courts are expected to exercise a parent's patriae authority. Courts now become more of parents to these children. So you find that where you have bought land with with an order of legal guardianship, I know a question is going to come where people are saying, if I don't have legal guardianship, but I want to sell this land, you might find yourself hand-tied. But courts have presupposed that the court can exercise that authority as a parent or carry the face of a parent to find out if this person claiming or having legal guardianship over these children is in a situation that he has been taking care of the children, among others, he can then transact in the land. There has been another case of, it was an application for guardianship. The cases we refer to on such for already decided cases. So we have no problem discussing them on such fora because they are the authority with which we also as lawyers rely on to make good other cases. It's the law of precedence. There's a case of Valeria Nachonyi Gonza. It was an application for legal guardianship by her father. It's Family Cause 199 of 2013. Court decided that in this case, court granted an order to a child's biological father, authorizing him to sell and or dispose of land. That was in block Chadondo, block 180, plot 662. The land is at Chitukutwe. It was registered in the names of Valeria Nachonyi, who was a minor. Now, that was for the benefit of the minor. So you find that where the circumstances presuppose that it is for the benefit of the minor, court will grant you legal guardianship. This will answer my question of when do you register the land in the names of the minor? Do you first need authority or you may register it without authority? Yes and
Actually,
no.
Council, as you're going on, I just wanted to bring out that question very, very badly because one of our sponsors for this conversation is Amity Realtors, and we know one of their number one service to the community is selling land, agricultural land, commercial land, and prime land in Mbara City. Now, I had wanted to actually get this properly because if I walk to Amity Realtors and I want to buy a plot, maybe an acre, and I inform Amity that this plot I'm buying is for my child. I had also wanted you guys to walk us through that journey properly because I know quite a number of people do that, but now you've talked about things like guardianship and all that, so I don't know if it applies here. But as you go on to the next thing that you wanted to talk about, would you kindly take us through that process as well, that as a parent, as a father, as a mother, I walk to a company like Amity who is selling land, and I tell them I want to buy an acre for my daughter who is in P5 now, and I want to know the right steps that I must go through with Amity to make sure that that land is belonging to my daughter, that even if anything happened, my daughter will still have it.
Now, this is what happens. Your child is in P5. We'll assume she is 10 years. You can do the transaction with or without an order of legal guardianship. You walk into Amity, you tell the manager, front desk manager, you need land. You're called Fred, but you're buying land for your daughter. That is okay. The land will be purchased. You'll make an agreement to that effect as a parent purchasing for your child. The title will be brought over, handed over to you, transfers made to that child for a consideration which might be a gift. Are we together? when you're transferring land from Amity to the child now, there has to be consideration. It's either you have bought it for yourself, you're giving it to the child. Now you want the child's name on the title. There has to be consideration, which could be a gift, because you're not selling land to your child of P5. So you're giving them a gift or donating the land to them. I talked of a donation deed in the beginning. You say, I, Fred, having purchased this land from Amity Realtors, I do donate this land by deed of donation to my daughter, Jessica, who is in P5, blah, blah. Now, when that title is being transferred from Amity Realtors to Jessica, there is a transfer form that is filled. Where there is consideration, it could be a gift. A gift to Jessica. Now, Jessica is in P5. Jessica is below 12 years. You need no consent from Jessica. Where Jessica is in P5, P6, P7, but she is above the age of 12 years, under section 43(1), or 1F, F is an amendment to the New Children's Act, section 43(1)F, you will require to have consent of a child who is above 12 years before, that is before that is when you chosen to have a guardianship order before the transaction. You'll require to have consent of that child. Where you don't have, where she or he is below 12, you'll just apply. Then, of course, according to their level of understanding, they might be quizzed a little. But the answer to your question is, you are free to go into Amity, buy land for your child. Now, the transfer process from Amity to you, or Amity to your child, or you to your child, may not be by purchase, because a child of 7 years may not have 100 million to buy land. So that transfer legally would be a deed of donation. You have donated. So that instrument is registered onto the title as a transfer to the names of your child. Then the child can have land in that name. Did I answer you?
Yes, Council, you did. You just did. Thank you.
Maybe going forward and back to ownership of property by minors, there are certain obligations and rights of a child that we need to look at. Section 4.1 of the Children's Act, as amended, provides for some of those obligations of a child. If we are to relate the same to land, a child has the right to live with his or her parent or guardian. Of course, living could be on land or property. Such property could be registered in the names of the child, like so many people do. They want to protect their face, so they will put land in the names of the child. The child has a right to live on that property. Part B of the same section, where capable, the child can express his or her view or belief or opinion on any matter that affects his or her well-being. I gave an example of where you want to sell land that is in the child's name. If this child is of understanding age, may still be a minor, but he or she is capable to understand and give an opinion on the ongoings. You want to sell land because the money lender is on your neck and it's in your child's name. That child has a right to give an opinion, whether yes or no. When he or she says no, the money lender could execute in other ways, but that was his or her opinion. A child has a right still to access information to which a parent, guardian, or other person in authority deems critical to the child's well-being. I gave an example of a matter where a parent wanted to sell land and he had never told the children that they have land in their names until they came to court. Court informed them there is land in your names, there is a title here. They showed them a title. This is your name, the three of you. So what is your opinion? I think excited as they were like, okay, this is our land. Then why does he want to sell it? So this section particularly gives children the right to know if you purchase land in your child's name from Amity Realtors, you have to inform the child by right that, you know what, James, I have bought this land. It is in Kacheka. It is in your names. The title is here. It is maybe kept in a safe place. As and when you get of age, that is mature, you can have this land to yourself or transact. Then, still under the rights, the child has the right to inherit property. We have over discussed the issue of inheritance, but a child has a right to inherit property. You can bequeath land. I talked of that in the beginning. You can bequeath land by will. You can bequeath land under a trust. You can bequeath land by gift for inheritance to a child who is a minor below the age of 18. Those are some of the rights under the law of a child. So then we need to critically look at the obligations of a guardian. You have obtained a guardianship order. You have land in the child's name. Will you dispose it off as and when you want, or there are certain parameters that you have to meet? Still, courts have had that decision discussed, and the role of a guardian has been described in many cases, among which is an application for guardianship by Wandera Peter. It is family cause number 4 of 2017. Justice Stephen Mobiru tried to define what a guardian is, or the obligations of a guardian. He says a guardian is a person who is given the legal power to make decisions for another person because he or she is considered not competent to decide for him or herself. Guardianship is thus legal relationship between a competent adult, who is now the guardian, and a person who, because of incapacity, such as minority, age, is incapable of taking care of his or her own affair. Now, that is the ward. There is a ward and there is a guardian. A ward is the child. The guardian makes decisions on behalf of the ward. The guardian, by virtue of that status, is authorized to make legal, financial, shelter, education, food, healthcare decisions for the ward. So those are some of the key obligations of a guardian to a child. So in the case of property, a guardian has an obligation to make a legal decision for a child. But like I have discussed in the cases prior, you find that still courts have to question. Yes, you have land. It is registered in this name, in the names of a child, and you have an order for legal guardianship. Do you just go on and dispose of the land? There is a question there. Because your role is to manage the property on behalf of the minor. Now, managing has to be in the best interest of the minor. The fact that you woke up and said the land is in the child's names is not per se your right to say, because I am the father or I am the legal guardian, then I'll dispose it off as and when I wish. You have to act in the best interest of the minors. You have to manage the property and any activities thereon with utmost care. You have to keep money, property of the minors separate from your own. You have to keep good records pertaining the properties. These obligations here push us to many times when we have what I will call in our local languages, omukuza, an executor. Your father has passed on, left property, and there is this gentleman here who is omukuza. your property includes mizigo somewhere, you have rentals, you have an apartment block somewhere, because this person either is an executor or has a legal guardianship order, this person has the duty to maintain proper records, keep finances separate from you. For instance, it's common with trustees. Trustees, they have in most trusts they have an obligation. You leave property, say a flat somewhere, and this trustee has an obligation to keep money for your education, maybe when you have grown up. So after a period of time, the trustee comes to give accountability to you. I was collecting such and such an amount in every month in your rentals. Here is the money, it's on an account, you can access it for your school fees, because those were the agreement of the settlement, the obligations under the settlement. So you find that such persons that transact for and on behalf of children in the property now have such obligations embedded on them to see that they properly manage property for these children. Maybe apart from guardians, who else has? I've talked of trustees, I've talked of guardians, I've talked of children above the age of 12 or can give an opinion. Trustees can transact for children. Parents can transact as parents and can also transact as legal guardians. Courts have granted legal guardianship to parents, biological parents. Then courts of law can also transact for children because they hold the mantle to make decisions where it involves the welfare of children. Certain texts, there is Bromley's family law, and at around page 336, I think, it states the children's welfare is the court's sole concern, and other factors are relevant only to the extent that they can assist the court in ascertaining the best solution for the child. So courts will always come in where the question of welfare is in check. They'll always come in and they will try to protect the welfare of the children. More so where it has property to deal with. Courts have also given directions, more so where transfers are involved. For instance, in there's a matter of Cheswa. It's a 2018 case, I think. Very, very young children, because the minors, and there were limitations to that. Funny enough, courts, there were 3 children. One was Cheswa, who an order was given for guardianship until 2030. Then there is Batwatwa, who is also a minor. The guardianship order is until 2027. Then there is Sebaduka until 2024. Now, what is funny about this application is, if these children reach age of majority, say 2030, Cheswa will be 18, he can transact in his land. So the guardianship order in this matter was limited to transfers and has to lapse upon execution of the said transfers or the minors herein attaining maturity age. So where the children attain maturity, the person with legal guardianship cannot transfer the property. But before they attain maturity, he has an order to transfer for those children. So that is both a protective measure. You are a parent, you have bought land for your children or in the names of your children, but still you want to transact in this land. How do you protect your interest? You get a guardianship order with a right or with an obligation, I'll say, to transfer that land. In that at any time that you want to transfer, you already have your order, you will just transfer to a third party or any person who requires to have interest in your land or that land of the child in these circumstances. So by far and large, that is the general discussion about ownership of property by minors in Uganda. Save if there is any
Fantastic.
question.
Yes, there are questions actually, Council. There are very many questions here coming in already. Some are very interesting, but let me start with those that are already on our comment section here. So, Doreen says, what would one consider when deeding property to a minor? I think maybe you hinted on that, but maybe you can still take her through so she can get her question addressed.
I think what to consider are two things. One, does the child have capacity, yes or no? In this situation, we are saying no, the child is below 18. So you will require to transact for that child. Two, over time, we have seen certain elements of fraud coming out. There is a transaction that was done. Doreen wanted to give children to her son. Now, Doreen bought this land 100 million. The child was 7 years. It is clear that in the donation deed or in the consideration part of the transfer form, you are going to say the consideration of that land was 100 million, to mean that the child bought that land at 100 million. It raises a red flag. It may not be today, it may be years from now, when someone has interest in that land and is saying, how could that child have bought land of 100 million when he or she was 7 years? It becomes a red flag. So that is why a donation deed comes in. That yes, it is me, Philip, who has bought the land at 100 million. But by all means, I cannot sell the land to my child. And I want my child to have that land. I donate the land to my child. That is where a donation deed comes in.
Okay, fantastic. Council, there is another question here, and it comes in from Bonnie. Bonnie
Yes.
says, my father bought me a farm of about 500 acres while I was 12 years, and everything was in my names. Now I am 27 years, and my father passed away, and now I get a lot of challenges with the sellers of the farm and some relatives. How best can I stand firm for this? Thanks.
Bonnie says, you'll pardon me a bit. Bonnie says the father bought land when he was 12 years.
Yes.
The land is in his names. Today,
Yes.
he's 27 years.
Yes.
What challenges does he get? Because this land is his, as far
Yeah,
as
he
the law is
says I
concerned.
get a lot of challenges with the sellers of the
Mm.
farm and some relatives. And he's
Mm.
asking how best can he stand firm for this. I think he's got some relatives that have been selling his land off, and he's saying how best can he maybe be able to protect what is left, or maybe even to claim what has been sold.
He can caveat what is left. That is one. Two, he can apply for cancellation of the titles of that which was sold without his consent, because under the law, under the RTA, that is the Registration of Titles Act, The certificate of title is conclusive evidence of ownership. That is section 59 of the Registration of Titles Act. Whether or not this land was transferred in his names when he was 12 years, for as long as that title is in his names and there is no element of fraud, that title and land belong to Bonnie. So anyone who transacts, of course, there will be those people who say, now your father, this land, we had even bought it with him. He was just hiding something, but the title is in his names. The land is his. He can apply for cancellation of titles to those who have been for that which has been sold off. He can also caveat the remaining property so that there is no more transfer on it. Those are the remedies I would give him.
Okay, so there is another person here in my WhatsApp who has been listening. They just sent me a question saying, what happens when a minor unfortunately passes on before they get their property from the guardian?
When a minor passes on, of course, this minor has not had the capacity to make a will or did not know about this land. It becomes a funny question. Then we will ask ourselves, are the parents still alive? If they are, then they can still transact in that land. Like I have said, it's about getting a guardianship order. But then that will mean you'll have to have proof of death, which is a death certificate, proof that you are the biological parents of this person. And if you have a legal guardianship order, then you can transact in that land. I don't know if you are together. I have bought land for my son. It is in his names. My son passes on. I cannot transact on that land because it is not in my names. But my son also did not have capacity to make a will so that he can give out that land or give it back to me. No, he did not have capacity. He was still a minor. So I, the parent, may apply to court, get a guardianship order to transact in the names of that child. For as long as I have proof, undisputed proof, that this was my child, I have birth certificates, I have the titles with me, the mother is there to attest, and I have all this evidence around. That would be the best way.
Okay, Council, then there is someone else here who is saying, in the case where land is actually left for two children, what happens when these two children grow up and say, for example, the parent did not say, my 4 acres, each of them will take 2, but he left the 4 acres for 2 children who are minors by then? What happens when they grow up and how do they share and who decides?
Now, this takes us back to the topic of joint ownership, where your parent has bequeathed land to you and you are 2 or 3 or 4, but has not allocated that this portion from the mango tree down belongs to so and so. Then by operation of the law, if it was titled land, he may not have specified whether your tenants in common or joint tenants. By operation of law, your tenants in common. So you have common ground. Your share is not divided. That is the operation of the law. Save if the title clearly marks that they are joint owners with, say, 50 shares or 50-50 ownership. Then that can be well aligned and demarcated. But that goes back to the topic of joint ownership of property.
Council, there is someone here who has made a comment, Lucy. Lucy says, I discourage apartments investment in my life. Just look between landlords and a farmer who is so much greedy in life. I think, okay, I think this conversation maybe Lucy just pasted a message or something. I don't know, Council, if you're able to look at some of the comments there but there is a comment which I don't clearly understand. Maybe let me first read it properly. But there is another one here in my DM. It says, if a parent has bought a property for their children and that property is not included in the will, does it mean that when a parent passes away, this property is specifically meant for the child and it is not going to be put under the custody of the executor?
We have discussed that prior. Whenever you give out property, it's a gift inter vivos. I am alive. I have a child. I have given this child property when I'm alive. There is evidence to that. I have told the neighbors, I've told the LC, I have told my wife that the land at St. Andrews, block this, belongs to Esther, my child. It does not form part of the estate. It does not form part of the estate. When I die, that is your property. I gave it to you when I was alive. It doesn't form part of my estate.
Okay, fantastic. I hope Nicholas got that answer. Nicholas is listening in from Canada, actually. Okay.
Maybe for Yugaman, to throw more light, there has always been that question. There are a lot of legal issues on that issue. So many, I'll use the example of girlfriends. Men have girlfriends out there. You have birth children with them. You give them a piece of land. When you pass on, it's a legal question, big one. When they pass on, people are coming and saying, you know what? This property belongs to our son. Oh, this property belongs to my husband and I am the widow. But this land was given to you. You have proof of that. It could be LCs, it could be friends, or the person you purchased the land from, your husband purchased land from. That land is yours. It does not form part of the estate. Because a gift inter vivos passes the moment I give to you. It passes the moment I say, my land in Kacheka belongs to Josephine. Or I have given it to Josephine. I have not been forced. I'm alive. There may not even be writing about it. I may not write. I may just state by word of mouth. Then that land does not form part of my estate when I pass on.
Fantastic. Ladies and gentlemen, thank you very much for tuning in. Now, at this time, if you have anything to supplement or question which has not been already asked, please go ahead and request for the mic. And I also want to introduce to you my sponsors for this conversation, Amity Realtors, the #1 real estate agency in Western Uganda. Now, if you're looking for agricultural land, if you're looking for plots, very affordable, genuine plots, and if you're also looking out for prime plots within Mbara City, there is only one agent to walk to. That is Amity Realtors Limited. I am so glad that Amity's director is actually on the call, a gentleman called Herbert. And we've always been discussing these things, Council Philip, that for the many times we've been here, people have always appreciated the services Amity is doing, and also the fact that they go ahead to educate the community and the masses in terms of land issues and all those questions that we always answer. Council Phil, as I wait for anyone who will be maybe requesting for the mic, what are those key takeaways that you want these ladies and gentlemen on this conversation to take tonight?
I always tell people and my clients, there is an aspect that we have, a legal aspect that we have not embraced. You see, when you talk about a will, someone will think they are dying, but there is an aspect of estate planning. It doesn't hurt, like we have said. You are still alive, you have money, 10 million. You think you don't want to make a will because it brings you closer to death, but you have money. You can buy land in the names of your child, put it in the names of your child. That land will belong to your child when he or she becomes of age. Because land is something that can be kept there. You just watch it over a distance. When time materializes, there's a title. That title is handed over to your child. These days, children are so sharp. By age of 12, they can easily understand and describe what a title is. So there shouldn't be fear that when we have money, then we want to hide property in the names of our children. Actually, the aspect of hiding property in the names of children could be the one with issues, because what you think you're hiding now, tomorrow might be a legal question when you want to transact or to give it over. But at that point, you lose nothing when you go into a lawyer's chambers, ask them to apply for a legal guardianship order. And legal guardianship orders are only granted by the High Court. After the grant, the new amendment provides that the guardianship order has to be registered, because sometimes you're in Canada, like our colleague who was on call. You're in Canada, you have bought land for your children in Kampala. You have to register that order as a document with URSB, then get it notarized. After that, you can easily transact in that property. But it is only critical that listeners take note that it is okay to buy land, put it in your children's names as minors. One, to protect that land until they grow and you give it to them, or to protect that land until they are grown and you don't part of estate planning. So that is my takeaway or my point to note.
Council, before you go, yes, before you go, I have Herbert on call here. I think Herbert has either question or comment. Herbert, if you could unmute your mic, how are you doing? And go ahead with your question or comment. Herbert, please go ahead. We can hear you.
Hello, Mr. Fred and our new speaker, Munyala.
Yes, Herbert, we can hear you.
How are you today? Thank you so much for today's episode. We appreciate the contribution Mr. Philip has given. I would like to thank the listeners today and the participant, Mr. Philip, today. Thank you for the insightful messages you have given us about the minors and ownership of property. Yeah, well, I wanted to speak a little about what we have. I don't know whether I'm audible, Mr. Fred.
Yes, you are very audible. Actually, we've always been missing out on this section, Herbert. And like today, I asked a question on Twitter. You saw most people were saying we also sometimes want to know what Amity is doing, because one of the reasons we tune in is we learn about land, but we also want to own land. So I think going forward, we need to be having this section where you tell us what is available at Amity, what offers you have for clients, because most people are actually interested in that area as well. So Herbert, go ahead.
Thank you so much for the opportunity. I thank the viewer and the listeners for taking time to learn one thing or two about land ownership and what is involved. Yeah, so about Amity, Amity Realtors is a real estate agency in Western Uganda. We buy land and sell. And apparently we are having commercial, residential, and farmlands in most parts of Western Uganda. And our prices are ranging from 3.5 for residential. If you want a residential piece of land in Western Uganda, we start from 3.5 going upwards, and we have a convenient payment plan for all this. We have commercial plots, we have farmlands. So in case you are out there and you need a piece of land from a trusted, tried agency like us, you need to hit us on our social platforms. We are on Facebook, we are on Instagram, we are on Twitter, and we are everywhere. We have a website where you can check on and see what we have available now. We have a variety of properties in and around Barara, and we are we always have places between the radius of 15 kilometers from the main city. Yeah, so if you need a plot or if you need something regarding what I've talked about, please don't hesitate to reach us out on our website, www.amiteuganda.com. And our social platforms, we are under the handle Amity Realtors Limited. Thank you.
Thank you very much. Ladies and gentlemen, I am so grateful that you always come through every single Tuesday, 8 p.m. Council Philip, well done, well done. This has been a very, very well discussed topic today, and I'll definitely convey the message to Council Alan that you did a very amazing job. Also, ladies and gentlemen, if you want to catch up with the episodes that we have been having, we have had like 9 episodes now. All the episodes that we have had in the past are available on Amity Realtors YouTube channel. You can go and catch those episodes. They are very insightful, very educative, and definitely you never know when the ideas or the knowledge you pick from those conversations is actually going to be applied to you, your relative, or even your friend. So I want to thank Amity Realtors for always empowering me. This is like our second year running. We've been having these conversations, and it is so important. I have learned a lot, and I am equally sure that even our audiences have had the same. So I want to wish you a very fantastic week ahead of you, and definitely I ask you guys, please keep engaging on the hashtag. If you have any questions, listen, sometimes we come to these conversations not simply to listen, but because we need to get in touch with the right people that are going to help us when we have issues, especially regarding land. Now, Council Philip is here, and Council Alan is always with us. Please go ahead, do follow them. You know, sometimes Twitter looks like a strange platform where strangers can exchange views and things like that. But hey, you never know when you need that counsel, when you need to make that decision, and you need a lawyer to give you some advice. So please go ahead and make connection. Tell the counsel we met on a Twitter space. He will give you an ear, and then you can be able to explain yourself. Otherwise, I want to wish you guys a very fantastic week. Please get better, not bitter. Lots of conversations going on, and get involved. Get involved, because we must get involved to get our communities to the next level. Have a fantastic night. Thank you, Amity. Thank you, Council Philip, and thank you, Council Alan in absentia, for always making this platform a better one. I'll see you guys again next Tuesday, 8 p.m. And of course, get better, not bitter. We will share our topic for next week. I'll see you then. Good night.